number 29 and 30, matter of Johnson versus the City of New York, and matter of Liuni versus Gander Mountain. Counsel?
Good afternoon, Your Honor. Robert Gray, Gray and Gray, on behalf of Appellant Thomas Johnson in Johnson versus the City. I'd respectfully request 1 minute for rebuttal.
You may have 1 minute, sir.
Thank you, Your Honor. May it please the Court, Respondents, Workers' Compensation Board, and City of New York have conceded in their briefs that the Appellate Division's decision in matter of Genduso was erroneous as a matter of law, and that there is no basis upon which a previous award for schedule loss of use to one part of a member should automatically be deducted from a later schedule loss of use award for a different part of the member. So with that in mind, there is no question that the decisions both in my case, Johnson, and in matter of Liuni must be reversed and that there must be a remand. The only remaining question is what standard the Appellate Division and the Workers' Compensation Board should employ upon that remand. Our position regarding that issue is that the appropriate standard is precisely the standard that is contained in Workers' Compensation Law Section 15.7 and in this Court's previous decision in matter of Zimmerman, which is that the injured worker should be compensated for the injuries caused by an accident in an amount no less than the compensation the statute provides for that accident and without conjunction, and not in conjunction with any previous disability. That standard would require the Workers' Compensation Board to assess the deficits that are causally related to any individual accident and to make an appropriate award for schedule loss of use based on the deficits causally related to that accident. For decades, the Workers' Compensation Board has promulgated guidelines to do precisely that. It has guidelines to assess the schedule loss of use of a limb based on knee deficits or hip deficits or elbow deficits or shoulder deficits and many other commonplace work injuries. In this case, the administrative law judge and the Workers' Compensation Board accepted the opinion of the treating physician that Mr. Johnson's left knee injury standing alone would have resulted in an 80% schedule loss of use of his left leg, and the injury to Mr. Johnson's right knee, evaluated alone, would have resulted in a schedule loss of use of 40% of his right leg. However, the board then deducted what the administrative law judge found were, quote, separate and distinct injuries from his previous accident involving his hips, based solely on the Appellate Division's decision in Genduso, which the board has now acknowledged is incorrect as a matter of law, and the city, in their reply brief to the amicus AFL-CIO brief, has also acknowledged is erroneous as a matter of law.
Counsel, the WCLJ did offer Mr. Johnson's physician the opportunity to opine as to the proportion of loss as between the two injuries to, I believe it was the left leg. Did he not?
What happened, Your Honor, is that Johnson's doctor submitted a schedule loss involving the knees only. The board directed the city to respond to the report regarding the knees only. The city then objected to that, and there was a hearing. At the hearing, there was a dispute about, in view of the fact that the man had previously gotten a 50% schedule loss award for his left hip, if the 80% report were considered, whether he could get, quote unquote, 130% of a leg. So that issue was briefed, and on the basis of this court's decision in Zimmerman, the judge issued a decision saying that because the new injuries were separate and distinct, the case could proceed and be evaluated on the injuries related to this accident alone.
So this raises
And the city didn't appeal that.
This raises the question that knees, hips are not actually listed as members in the relevant sections. So how do we get there? How do we aggregate knees and hips and aside from legs, which is the named body member?
Right. Well, Your Honor, I'm certain that in 1914 and 15, the legislature, when it enacted the statute at that time, understood that someone could injure a part of a leg and not the entirety of the leg. And as a result, it provided in the statute compensation for parts of members, and it also provided compensation for proportional loss of a member. So essentially what the respondent's position is that the loss, well, I'll state my position. My position is that the schedule in the statute is simply the means of calculation of the award related to the injury. So if in this accident, the man has a 50% or an 80% or a 40% loss of use of his leg, the statute provides that you're going to take 40% of 288 weeks for a leg. You're going to multiply that by his benefit rate, and that's the method of calculation of the award. There is nothing in the workers' compensation law that is a lifetime cap on anything. The statute 15.3, in fact, leads with, in case of. It doesn't say in all cases of, it doesn't say no matter how many injuries the man ever has, this is his lifetime cap. Everything in the statute is case-based. If the worker has a new injury, he has a new date of accident, the notice provision runs anew, the statute of limitations runs anew, the periods of temporary and permanent disability are calculated anew. He
Does
has
the
a new
plaintiff-
average weekly wage.
Does the plaintiff then have to establish that that new injury caused greater disability that was not compensated for?
Absolutely, Your Honor. There's no argument here that any injured worker should receive duplicate compensation. So if in injury number one, the deficit is a 90-degree loss of flexion in the knee, and following injury number two, the loss of flexion in the knee is exactly the same, then there's no additional award. But if in injury number one, the worker has one deficit, and injury number two, they have an entirely different deficit, the statute provides that compensation should be provided for injury number two without regard to the previous disability.
And if the sum of the deficits should exceed the award that would be given for a total loss of use, that's just how it goes?
In no individual case can the worker receive more than 100% of a limb. That's clear.
By individual case, you mean an accident?
In one accident,
Yeah.
right. I mean, that's fundamentally what the dispute here comes down to.
And what
it's
about the
really
aggregate?
It's really the only point of dispute between us, and I know the city, and I believe the Workers' Compensation Board, is whether the schedule in the law is a per-case limit or a lifetime limit. The complication of making it a lifetime limit is, to take Zimmerman as an example, the man had a below-elbow amputation. He was assessed as having an 80% loss of use of his arm. Any subsequent employer now reaps a windfall. They're required by law to purchase a workers' compensation policy to cover benefits for their employee, but their liability for that employee is limited to another 20% of the arm. If he had had a previous, if the previous injury had been evaluated at 100% of the arm, and Zimmerman had a subsequent accident and had an amputation at the shoulder, under the respondent's approach, he would get nothing.
Can I ask you about Mr., over here, sorry, about
I'm
Mr.
sorry, Your
Johnson's, his left leg, just for a minute?
Right.
The way I read the record, Dr. Long opined that he had a 40% scheduled loss of use in the left knee. With me so far?
It's the right, but
Oh,
yes,
sorry,
Your
it's
Honor. I had trouble remembering them also.
Okay. It's the right?
On the right, he was assessed as having 40% for the knee, and the board deducted from that a previous 52.5% for his hip and
did he
gave
get
him
the
0.
40% because of the total knee replacement?
Correct.
And the IME also awarded 40% because of the total knee replacement.
The IME gave him 40% on the left and 27.5% on the right. The treating doctor gave him 80% on the left and 40% on the right. The board gave him nothing for the right, notwithstanding the fact that everyone agreed that there was a causally related disability.
Well,
to the right.
that's ultimately where I was going, is that even the city's IME would give him something.
Yes, Your Honor, that's why everyone agrees that Ganduso was wrongly decided. Everyone agrees that there was a causally related deficit to both knees related to this accident, and that the man should be compensated for the causally related deficit to his knees for both accidents. There, everyone agrees that he should not have I think, that he should not have gotten 0 for his right leg. The sum total of the dispute is whether he was entitled to an independent evaluation of his left knee without regard to the prior, as opposed to you have to look at them both, and under no circumstances can they exceed 100, which the cases refute. I believe my time's up, Your Honor.
Yes, sir, it is. Thank you. Counsel?
Thank you, Your Honors. My name is Justin Teff. I represent Joseph Liuni in the matter of Liuni versus Gander Mountain. I am going to start by saying I agree with everything that Mr. Gray had
Excuse me,
said in terms of...
Counsel, are you requesting any rebuttal time?
Oh, no, I'm sorry, Your Honor.
Okay,
No
thank
rebuttal time. I agree with everything that Mr. Gray said in terms of what remains for the court in terms of determination at this point. But I did want to add, because the one point that seems to have not been conceded by the employer in my case, and a point raised by the court here today, as well as, quite honestly, every learned counsel for employer and carrier that I've discussed this with, as stated by the court, how do you get past the fact that the statute plainly uses the word arm and plainly uses the word leg? Having thought quite a bit, I have an answer I'm completely comfortable proffering to the court. Your Honors, we respectfully submit that although the phrase plain language is one that is thrown around quite a bit by lawyers in various contexts, the true and penultimate goal of statutory interpretation is not slavish textualistic adherence to the plain language of the statute. Rather, plain language is merely the first in a series of successive tools which we utilize to try to ascertain, if it is not perfectly clear, the true intent of the legislature that passed the act. In fact, while it is a bit down on the list, there is actually a canon that says that if slavish adherence to the text yields a result which is seemingly absurd within the context, then that approach is to be reconsidered. Admittedly, Your Honors, I was not a member of the state legislature in the second decade of the 20th century, but I do know that this was a body that passed one of the first in our nation of these Progressive Workers' Compensation Act, only to see it quickly struck down on constitutional grounds. That same body, more or less I imagine, then undertook the utterly momentous task of securing passage of a state constitutional amendment that would permit enactment of the humanitarian act they so desired. That same body then repassed this worker-oriented law, which, by the way, was not of general applicability at the time, but was specifically limited to a list of the known most hazardous employments in that era. Now, in order for the employer's argument to hold water, as it were, what needed to happen in the midst of all this, in the session chambers just a few blocks from here, is that this very same body of legislators that undertook this momentous task thought, wait a minute, here's an idea. After all we just did, what if we word this very carefully to ensure that all of these workers will only be permitted to suffer one major injury to each joint in their arm or their leg, for instance, the shoulder or knee, and will never again be permitted for the rest of their working lives to be compensated for any permanent loss to any different joint in the same extremity, such as the elbow or hip. Yes, there it is. Let's finally get this passed. Let's get it over to the governor. Your Honors, I find it highly doubtful that this seemingly absurd result would represent the true intentions of the lawmakers that struggled so diligently to promulgate this revolutionary humanitarian act. As well, I find it highly doubtful that this honorable court got it wrong when it was presented with this very issue 51 years ago in matter of Zimmerman and decided that indeed an injured worker in New York may be compensated for different injuries to different joints in the same extremity. And, Your Honors, I find it highly doubtful, as it seems to have been conceded by most in the courtroom, that all of the rest of us have been getting this wrong for 100 years, until somehow 4 years ago the holy grail of workers' compensation was unearthed. For these reasons, Your Honor, as well as those set forth in our brief, we respectfully ask this court to reverse the order of the appellate division and remand this matter to the board with a very specific instruction that there is utterly no black-letter prohibition against an injured worker being separately and distinctly compensated for permanent injuries to different joints in the same extremity, and that indeed this is a determination that is a matter of substantial evidence.
Counsel, just as a point of order with respect to Zimmerman, that involved what was even then 2 separate members, did it not? It was a hand, which was listed, and a different part of the arm, which is included as a different member.
I'm sorry, Your Honor.
The injuries that were added together in Zimmerman, they involved 2 different specified body members, did they not?
And in what frame of reference are you asking, my case or Zimmerman?
Well, you made reference to Zimmerman and how.
Okay. I believe Zimmerman was two different parts of the arm, the elbow and the shoulder, if I'm not reading it incorrectly, Your Honor. The hand is separately enumerated.
And you don't think that Zimmerman's injury was to a hand and a forearm? You think it was an elbow and a shoulder? Is
I
that?
believe it was shoulder and then forearm, elbow from the way I read it, but again, forgive me if I'm misinterpreting that, Your Honor.
Well, I may be misreading as well, but it seems as if the analysis would be different if you're talking about two differently enumerated members.
We don't believe that it is, Your Honor, because we, again, cannot believe that after going through all that they did, the legislature intended each of these dangerously employed injured workers to be able to suffer only one injury to each of the major limbs in their extremity throughout all of their working lives, or pardon me, each of the joints. Hip or knee, elbow or shoulder, that seems incongruous, again, with the background that we believe is set forth. That said,
Well, counsel, if I can interrupt you, I'm on the screen.
Oh, sorry,
So-
Your Honor.
Sorry about that. Well, in your case, I understand the point you're making, but I'm not sure how relevant it ends up being at the end of the day. Because didn't the expert that was credited say that the injuries to the different parts of the member were wholly unrelated?
in our,
There was no overlap, isn't that the difference potentially between your case and Mr. Johnson's case?
it can be viewed as a difference, certainly, Your Honor. We would
Well,
not,
it may be a dispositive difference. I mean, that's the position the board is taking, or at least potentially could be a view of your case.
I'm going to maintain that as a matter of law, Genduso was the controlling factor here, and seemingly, therefore, we should start with removing that. And then if records need further development, they can be further developed. But to have a blanket black letter rule that no injured worker in New York may ever have a separate permanent injury to the elbow or the shoulder just does not make any sense.
Thank you, counsel. Counsel?
May it please the court. The board asked this court to do two
Counsel,
things.
please put your appearance on the record.
Brian Ginsberg for the board, Your Honor.
Thank you.
May it please the court, the board asks the court to do two things in these appeals. Number one, the court should hold, which I think is now common ground among everyone here, that a second schedule award for an injury to a different part of the same enumerated member is limited to any additional loss of use of the member as a whole. Second, the court should further hold that the calculation of whether and to what extent the injury to that different part of the member causes additional loss of use of the member as a whole is a case-by-case determination based on the totality of the credible medical evidence introduced in that case, not susceptible to a categorical rule.
So if
The
we
court-
adopt that rule, what would we do in these two cases?
Well, if you were to adopt those two baseline rules, we think there's still enough based upon the peculiar facts of Johnson to affirm the Third Department's decision in Johnson. As Your Honor's colleagues were interrogating with my opposing counsel, there seems to be an independent failure of proof, just as an evidentiary matter, when the doctor was prompted to give evidence of any other injury to the leg that was greater than the 40 or 80% he had isolated for the knee. He didn't come up with any, so that 40 or 80% was stuck.
That's Dr. Long, but what about Dr. Parisian?
Oh, the other doctor gave more, gave a different picture of things, but Dr. Long was the doctor who was credited.
No, I understand, but the independent medical examiner, let me ask it this way. Is the report, and I think he was also deposed, deposition from Dr. Parisian, would that have been sufficient to, under your formulation of the rule, evidentiarily sufficient to support the award, the scheduled loss of use award that doctor came up with?
Yeah, I think that might have. My limited point is that there is substantial evidence in the record to sustain the credibility findings that the workers' compensation law judge and the board actually made. So again, we're asking for a new legal rule, no question about that, but no one, at least we are not asking the court to undo the factual findings of the workers' compensation law judge and the board to the extent those findings are based on substantial evidence, which is the case in Johnson. I think we all agree that in Liuni, there would have to be a vacate and remit to the board to be properly instructed to apply these case-by-case rules that I just set forth as opposed to the categorical rule of Genduso. And we don't have any strong objection to a similar vacate and remit in the Johnson matter either. Really, the board's interest is, at the end of the day, this court should set forth, should make clear those two rules that I opened with.
Yeah, I'm getting at something a little, or trying to get at something a little different, which is not what the result in that case ought to be, but under your formulation of the rule, which turns on the sufficiency, I mean, the reason you're rejecting Long is because you think that's insufficient under the rule you're promulgating or proposing to satisfy his evidentiary burden. If instead, what I'm trying to get at is, if instead his doctor had testified and provided a report in the form that Dr. Parisian's, would that have met the evidentiary standard you're seeking for?
I think it would have met the evidentiary standard. I also think, though, that that would run into an additional legal hurdle, which has been referenced a little bit today, which is the 100% limit. Johnson, namely, would need legal authority to recover compensation for greater than 100% of the loss of use of the given member. And there's no authority for that in the workers' compensation law. As a common sense matter, you can only lose 100% of something. You can't lose any more than that. You can't lose something twice. So one would think that Johnson would need to find an exceptionally clear statement in the workers' compensation law, in the case law, in some authority for that counterintuitive contrary rule, and there is none. What Johnson relies on to exceed the 100% limit are decisions from this court, from the Appellate Division, 3rd Department, and from the board that are all follow-ons, Your Honor, to the Zimmerman case. And all of those cases, like Zimmerman, involve awards for the loss of use of multiple separately scheduled members, such as, indeed, it's the case in Zimmerman. This is most clearly stated in the Appellate Division decision in that case. There, the hand and the arm. The hand is anatomically, of course, a component part of the arm, but they are both statutorily separately scheduled. So even in Zimmerman and the cases that follow Zimmerman from the 3rd Department, from the board, et cetera, no court nor the board has ever authorized, to my knowledge, has ever authorized recovery of greater than 100% compensation for any single separately scheduled member. And, you know, I'm not sure exactly what the employer in Gander Mountain is going to get up here and say, but they seem to advocate a categorical, in their briefs anyway, a categorical rule in their favor, that injury to a different part of a member never constitutes an independent loss of use of the member as a whole and always justifies an offset, basically the Genduso rule. We don't find any support for the Genduso rule in the decisional law or in the workers' compensation law. The Gander Mountain employer for that point, and Genduso points to 15 sub 7, but that just says that compensation for an additional loss of use of the member is limited to that actually caused by the specific injury. In any given case, medical evidence could come in, as it did, at least potentially in the Liuni case, showing that those injuries are separate and independent. And for the reasons that I think your honors have been exploring with my colleague on the other side, the categorical rule in Johnson is similarly unsupported. And I'll just close with one statutory point on that before I sit down. My friend on the other side, representing Mr. Johnson, referred to, I think he was intending to refer to workers' compensation law 15 sub 3 sub U, which authorizes an aggregate schedule award for the loss of use of, quote, more than one member or parts of more than one member set forth in paragraphs A through T. And he was invoking that provision in an attempt to show that this authorizes sort of a blinkered part-by-part analysis as opposed to a loss of use of the member as a whole analysis. The text itself refutes that because that modifier, quote, set forth in paragraphs A through T, that applies not only to the word member, it applies to the word part also, and it therefore means that the only parts of members that can qualify for separately enumerated awards are those that are themselves separately scheduled. So we're really back to where we started, and I'll close with this, that there are no categorical rules in this analysis. It's a case-by-case analysis to determine whether whether a successive injury to a different part of the same member fully translates into an additional loss of use of that member as a whole, partially translates into an additional loss of use of that member as a whole, or doesn't translate at all. The board should be permitted going forward to make that determination on a case-by-case basis based upon the evidence presented.
Thank you,
Your Honors.
counsel. Counsel?
May it please the court, Daniel Matza Brown for the City of New York is the employer respondent in the Johnson matter. This appeal is fundamentally about administrative law judges' fact-finding authority. And in particular, the key question here is whether the administrative judge had the authority to require Mr. Johnson to bear his burden of proof, by which I mean to require Mr. Johnson to show the amount of loss of use of his legs that had not been previously compensated in the prior award. Now, I want to focus on Mr. Johnson's left leg, because I think that if we walk through the evidence there, and if we walk through what the administrative judge did with respect to the left leg, it becomes clear why affirmance and not remand is warranted here. For the first award, Mr. Johnson presented evidence of impairment to his hip that translated to a 50% permanent loss of use of his leg. And I want to emphasize permanent here. My colleague, speaking for Mr. Johnson, I think never wants to use the word permanent, but these are awards for permanent losses of use. For the second award, Mr. Johnson then submitted a written opinion of his doctor saying that he had a knee impairment yielding a 80% loss of use. The administrative judge essentially asked counsel, are you saying that your client's entitled to 130%? To which counsel said yes. And I think the administrative judge then probably scratched her head a bit and said, all right, if you're going to come to me and say, my client has 100% loss of use, or maybe even more than 100% loss of use, cumulative total, you're going to need to prove up your case. And so at page 139 of the record, the administrative judge said, I want the doctors to testify as to the loss of use for all sites, for all the impairments to the leg, so that they could prove up the cumulative loss of use, which would then permit the administrative judge to determine what percent loss of use of the legs had not been previously awarded and previously covered in the first award. Mr. Johnson's doctor declined to address that issue in his testimony, and in fact he testified at page 186 of the record that he was not even asked to do so. Right? We can understand why strategically the claimant's attorney may not want to have asked the doctor this, because a doctor will not get up under oath and say, oh, I believe the cumulative loss of use is 120%, right? It's, as my colleague said, it's a factual impossibility, right? So the claimant's attorney hoped to get the 130%, but it is completely rational and completely within the administrative judge's fact-finding authority to ask the medical experts here to assess the cumulative loss of use of the member. When no additional evidence was put in, the highest number the administrative judge had was 80% loss of use for the left leg.
So Johnson is a failure of proof.
Johnson is a failure of proof. That's exactly correct, Your Honor. And what the administrative judge did finds ample support, strong support, in both the statutory text and the statutory intent.
So let me ask you then about Dr. Parisian's opinion that Mr. Johnson suffered a 40% causally related scheduled loss of use of the left leg. Is that cumulative or non-cumulative?
I'm sorry, 40% of the left leg, Your Honor, or the right leg?
40% of the left is what I'm reading from his report at page 119 of the record.
Bear with me, Your Honor. Page 119, you say. All right, well, that is the city's doctor,
Right.
whose opinion was not credited by the ALJ. But
Right.
to turn to your question from before, which I think is what you're getting at, is this notion where if both doctors found some
No, I'm asking
impairment.
something, I'm sorry, I'm asking something different, which is,
Okay.
you want the doctor to opine on the cumulative loss, right? That's the relevant evidence as far as you're concerned, the cumulative loss to the leg.
It is, and the reason for that, Your Honor, is you can't look at each impairment in isolation and assume that they're
Right,
summative.
I don't want the reason, I just want to know if that's right, so I can move to my next question.
Yes.
Okay, so your doctor says 40% causally related to scheduled loss of use of the left leg. Does that meet the cumulative requirement you were trying to impose on the plaintiff, the claimant, or not? Or is this just irrelevant?
Well, Your Honor, I think that the claimant does bear the burden, but I think that here, these numbers, if they're cumulative, do not
That's
warrant an
my
additional
question
award
is-
because they've already been compensated for in the first
That's
award.
my question, is the 40% cumulative or not cumulative? This
It's
is your
not clear,
doctor.
it's not clear from this report, which is why the administrative judge specifically instructed to receive additional evidence at that juncture in the proceedings.
So your doctor put in evidence that you don't know whether it's cumulative or not cumulative.
Your Honor, so
It says causally related.
So this is how I look at it, Your Honor. There are the guidelines, which are very, very helpful for consistent awards for single impairments, right? The guidelines have single impairment rubrics that allow for consistent awards, but the guidelines also say at page 48 of the 2012 guidelines that govern in Johnson that we're not going to put forth mathematical formulas because it's too hard. They're not purely summative, right? And we know that, right? If you add a cup of water to a cup of sugar, you don't get 2 cups of sugar water. And you can have similarly symbiotic or related injuries to different joints, right? So if, for instance, your hip does not move at all, you cannot walk, right?
I get all that. I'm really just trying, what does causally related mean?
Well, Your Honor, I think that that's where we all get really tripped up because it's somewhat conclusory to say related or not, right? We know in this case that Mr. Johnson's own doctor said that these injuries are related. And so the question is, right, how much are they related, how much are they not
I'm asking you about
related?
your own doctor, right? I mean, presumably you have some idea of what your doctor was saying. I guess.
So this opinion that you're referencing here on page 119
Yeah.
is he's saying, if I examine the knee on its own and I look at the guidelines, then that knee impairment would result in this percentage loss of use and without regard for any other injuries and how they sum or how they do not sum.
Okay, so he's not actually providing evidence that would meet the evidentiary standard you would like to have us adopt.
No, but what I think was rational on this record, Your Honor, is that after these written reports were put in, the administrative judge looked and said, you know, you're asking me for 130%. That doesn't make sense to me. So I think that the best way in this case would be to get a cumulative estimate. And at that point, it was fully within his authority as the adjudicative administrative judge to find facts in that manner. And that's why affirmance is warranted here.
Okay, counsel, can I just, I'm on the screen.
Oh, yes.
So I just want to understand this point about this record 119. I think what you're saying is that the statement from the doctor is, if I looked at this injury to the knee, I would say it's a 40% loss to a leg that has no other injury, a leg without any other problems. Is
That's
that what
exactly-
you're saying the statement is?
Yes, exactly, Your Honor.
Okay, and so, but your position is that, I believe this is obviously the board's position here, that the point of the statute is you are going to be interested as the board and as the ALJ in figuring out what's the impact on the entire member, right? In terms of the impact at the time of the injury. That is to say, if you've already got a member that has some reduced use, you're looking at, well, how much more reduced use is there based on this subsequent injury? Am I understanding you, and that's why the statement on 119 didn't, as I'm understanding your point, didn't answer the workers' comp ALJ's concern?
Yes, with just the slight point that because these are permanent losses of use, it's not at the time of the injury, but it's at the time of full medical rehabilitation.
Yes, I'm sorry, yes.
But otherwise, yes,
Yes,
I'm exactly on
correct.
board with what you just articulated, Your Honor. Yes, I think that's correct. And what the administrative judge did here finds strong support in the statutory text, because if you look at subsection 7, it clearly forbids double recoveries, as everyone here agrees. And if you look at the statutory schedule, what we have is we have the legislature carefully selecting specific members and very carefully selecting specific recovery amounts for permanent loss of use of that member. We have 244 weeks, 288, 312. With immense precision, the legislature decided on these per member limits. And if you look at subsection S, which says that you get less than that amount for partial permanent disability, and then if you look at the other sections, such as subsection 8 and subsection V, those allow for additional recovery beyond the schedule. So my colleague's concerns about these being lifetime limits for forever is not borne out by the statute. But what these are is for cases like these, they are per member limits for permanent loss of use of that member. Zimmerman does not hold otherwise. Zimmerman simply affirms the board's broad discretion to issue appropriate awards based on the schedule. And as Judge Canataro noted, it involves two different members. If you look at the third department decision, the dissent, because this court said to the third department, no, you cannot limit the board the way you're doing it. The third department decision makes clear that it's the loss of use of the hand that was compensated in the 1920s.
Counsel, in this case, and do we have to actually resolve this dispute over whether or not there can be an award that exceeds 100%? Do we have to resolve that here?
No, Your Honor, we don't. But I think that what the claimants and the appellants are arguing Zimmerman does is it requires the board to give awards exceeding the per member limit. And I think it's clear that Zimmerman does not require that. And the statute certainly does not require that. And so it was within the administrative judge's authority and discretion here to
I guess
say-
what I'm saying is if we agree with a different rule, perhaps your rule, perhaps Ford's rule, or do we have to resolve the question of the cap?
No, Your Honor. I think that you don't have to resolve the question.
We can leave that for another day, right? It's not implicated here necessarily.
That's right, Your Honor. The evidence, all the claimant put in was an 80% number for the left leg. He had the opportunity to explain, to prove up additional cumulative loss of use from both impairments and failed to do so. So on this basis, there's certainly substantial evidence supporting the award.
Thank you, counsel.
Thank you.
Counsel, your rebuttal? Oh, excuse me, I'm sorry. Mr. Chase.
Good afternoon. I'm Jeff Fox. I'm replacing Mr. Chase today, but good afternoon, and may it please the court. I'm sorry to end by taking a little different position than everyone else today, but I disagree respectfully with my colleagues with regard to the Genduso decision and that whether it was proper or not. This court first spoke on the issue of the relationship or the interrelationship between larger members and their component parts in the matter of Flicker versus Max Sign Company in 1930. And in that decision, there's very specific language saying that in the absence of exceptional conditions, compensation for the loss of a large member must be accepted as compensation for the loss of its component parts. In other words, as part of the calculation that's been referred to a few times, 312 weeks for an arm is taking into account all the component parts that are involved in an arm. So that's why the court in Genduso said there's only 4 different types of larger members for which the statute allows for scheduled loss of use findings. That would be the foot, the arm, the leg, and the hand. The leg and the arm come into play the most with regard to this issue. But Flicker did indicate exceptional circumstances, and that's our position is that Zimmerman was in fact an exceptional circumstance. The unfortunate situation in that case was an amputation 6 inches below the elbow. The court seems to indicate that under the guidelines it would have been amenable to a scheduled loss of use of 100% of the hand. It seems like they sort of prorated it into 80% of the arm. And then several years later, the individual was working with that amputated limb and suffered a distinct injury to what was remaining of his arm. We would certainly admit that it would be a draconian result to not allow him to have some compensation for the permanency associated with the remaining part of his arm. But that's completely different than what we have before you today, which is different component parts of larger members and whether they can be separately awarded scheduled loss of use awards. There's nothing in the statute awarding a schedule for a shoulder or an elbow, only the arm. Mr. Liuni received a scheduled loss of use of the left arm from his 2007 injury of 22.5%. That was utilized, a 312-week figure was utilized to calculate the award, which ended up being 70.2 weeks. Scheduled loss of use awards are not attached to actual lost time, so that's a measurement of their anticipated future loss of wage earning capacity from the loss of the arm. Subsequently, he sustained the injury in 2014, for which he had the scheduled loss of use of the left arm from the shoulder condition, which was a 27.5%. So it's our position that a 5% increase is appropriate, and we'd ask that all decisions be affirmed. Thank you.
Thank you, counsel. Now, counsel, your rebuttal.
Thank you, Your Honor. I'd like to clear up what I think is a fundamental misunderstanding about the record here. This case was litigated on the basis of the Court of Appeals decision in Zimmerman. The city's position during the litigation was that we needed to produce a report with an overall loss of use of the leg apportioned between the two injuries. The decision that the city points to at page 139 of the record, if you read the entirety of the decision and the brief that was submitted before that, found that the man did not need to do that. The judge found that the claim for the disability to the knees was separate and distinct from the previous disability to the hips. And the reason that the judge made that decision was because of the city's argument that the previous 50% for the hips, for the left hip in combination with the 80% to the left knee would have resulted in more than 130%. The direction for testimony to consider all sites was on the question of whether the medical proof would then establish that the knee deficits were independent of the hip deficits, which is what Dr. Long testified to quite clearly. He testified it was a challenging situation, he did the best he could, but ultimately he stated, I believe at page 184, that the pre-existing hip schedule losses did not affect his opinion regarding the knees. And then the judge went on to find that had the man had no problem with his hips prior, he would have had 80% to the left leg for his left knee and 40% to the right leg for his right knee. The only reason that the judge did not make those awards was because between the time of her first decision, when she found that the knees should be considered independently of the hips, and the time of her second decision when she made the award, the appellate division decided again to do so. So the case was litigated based on the state of the law prior to Genduso, which is that a new injury receives a new evaluation and that the award should not be affected by the previous disability, which is what the statute says. And just briefly, Your Honor, to answer your question regarding the facts of Zimmerman, the facts of Zimmerman are that the man had an amputation 6 inches below the elbow. If you look at the current Workers' Comp Board guidelines, an amputation 6 inches below the elbow is considered 80% of an arm because the forearm is an arm, not a hand. Had the award been for 100% of a hand, then the award would have been 78% and not 80% because a hand is 244 weeks and 244 over 312 is 78. So the fact that the award was 80%, in my experience of 3 decades in this field, indicates that the prior award was an arm award, not a hand award. And thus, Zimmerman, as here, was 2 unrelated deficits, as the court found, involving the same member. Lastly, what I'll say is if the court adopts the respondent's position that a worker is limited for their lifetime to 100% of a member, not only would that contradict the statute, it would result in exactly the thing that happened with Mr. Johnson for his right knee, which is in the face of a concession by the employer's consultant that there was a causally related disability, and Dr. Parisian examined only the knees. So his opinion was solely related to the knees, just as Dr. Long provided an opinion solely related to the knees. then you will have injured workers who wind up with zero compensation, which is what happened to Mr. Johnson with regard to his right knee. You know, by contrast, you have in the history of the law in the last 50 years, 5 cases that address the issue of whether you can get more than 100%. So I would respectfully suggest to the court that the evil to be avoided here is not overcompensation, but undercompensation.
Thank you,
Thank you.
counsel.